Welcome to the Collateral Base. Today is the newest in our case law update series. We'll be discussing the Uniform Fraudulent Transfers Act and whether an asset transferred is subject to the act or not. And it'll provide guidance to creditors as to whether a transfer is actually subject to the act. Let's get to it. In the case of Plusek versus Vandenberg, Illinois' 3rd District Appellate Court joined with other courts across the country to say that an asset that is encumbered by a debt does not qualify as an asset under the Uniform Fraudulent Transfers Act. However, you need to have evidence to determine what the fair market value of that asset is. It is insufficient just to say that the creditor was paid in full and therefore the transfer of the asset is not subject to the Uniform Fraudulent Transfer Act. You have to say the creditor was paid in full and the fair market value of what the creditor was paid is what the real estate or the other asset, typically real estate, was worth. After they had transferred some real estate that was encumbered by an indebtedness that was satisfied through the transfer. And the Vandenbergs argued that therefore the asset that was transferred, because it was encumbered, was not subject to the Uniform Fraudulent Transfer Act. It's true that the UFTA defines asset to explicitly exclude things that are validly encumbered by liens. However, if you have a $50,000 lien on a $100,000 house and you sell the $100,000 house to a third party, this third party is perhaps a Vandenberg trust, as it was in this case, for the indebtedness. So you've sold to this trust a $50,000 payoff to the bank, and now you've gotten $50,000 worth of equity. But you would make the argument that that transfer was exempt because the asset transferred had a valid lien. Illinois has now joined the other states in saying, of course, that $50,000 of the $100,000 house was not an asset. But that other $50,000, that is an asset. And before you can grant a motion for summary judgment, you need to have evidence that shows not only the satisfaction against the bank or the indebtedness, it doesn't have to be a bank, encumbering the asset transferred, but also the fair market value of that asset. And that just makes sense, because otherwise you have a windfall like the situation with the $100,000 house. So the next time a debtor tells the bank that, oh, the transfer of the piece of real estate, well, there's a mortgage on that. It wasn't a transfer, a fraudulent transfer at all, no. What was the value of the real estate being transferred? The fair market value, not the satisfaction value, but the fair market. That's going to let you know whether or not there is a claim under the UFTA for transfer. The $100,000 house is a wonderful example to illustrate the holding out of this Plusek versus Vandenberg case from the 3rd District Appellate Court in Illinois. Thank you for joining us on the Collateral Base's most recent case law update on new cases that impact community banks. See you next time on the Collateral Base.